Hi, Bill Henshaw here again, Constitutional Kook headquarters, and some very good news for all of us here. And I should have been doing this before, but I've come into possession of a document here from the Territorial Secretary of State in Sacramento, and they say right in here, I'm going to hold it up. You can read it. I'll send you this request for information. You win in court at gmail.com. I'll send you documents like this and other ones. Says the California Constitution of 1849 was not repealed. Therefore, we have no documents to respond to your request. What does this mean? Well, in concert with the fact that they're saying the state does exist, and apparently like it originally did, and if you don't know what that is, Article 2, Section 1, California Constitution, 1849, free, white, male, 21. See you later. That is what it is. There's nothing racist about it. And it hasn't been changed, certainly not by the ratification of the non-existent 14th War Amendment. Yet here we have the California Supreme Court, such as it is, no qualified members, not even anyone remotely qualified to be on there. And with the documents you get from me in my document packets, I have at least 12 different documented occasions where they suspended the non-statutory federal writ of habeas corpus, Article 1, Section 9, Clause 2, which you can't do except in cases of rebellion or invasion, not COVID pandemic. Suspended it and said in effect that the questions you ask are beyond the jurisdiction of California courts as they appear to raise federal questions. What? That court doesn't have federal question jurisdiction? And yet, as I said on some other videos of mine, during my course of my vacation in South Carolina, 5 months as a political prisoner 5 years ago, case came on the news there. It never, as far as I know, got to the courts, but some idiot lawyer was claiming for his transgender entity that he had a right to select his public bathroom because taking a crap in a government-funded bathroom affects interstate commerce. And the California Supreme Court has said over and over, and now to the point they won't even file documents, that the questions you ask are beyond the jurisdiction of California courts. What the hell? What are they saying here? What do they think California is? I have no idea. But it's certainly not a state. And now we have the heads of two ostensibly different departments of government saying different things. So how in the hell can we know where we are? And this is true for you out there in Illinois, Ohio, Pennsylvania, Michigan, Wisconsin, wherever. We don't know where the hell we are. How can we possibly put on any defense, especially to a quote unquote criminal charge, most all of which are commercial, which are beyond their jurisdiction anyway, if we don't know where we are, what the rules of the game are, the identity of the elements of the crime they must prove to get a conviction, and most importantly, the identity of the alleged injured party, so we can invoke our right to confrontation and cross-examination. And this is all in the bill of particulars that you get with my document packet. So send me an email, youwinincourt@gmail.com. And that one document alone, without more, beats the bastards. I mean, they're saying you can't go in there, you're stupid, you're ignorant, you need an attorney. And by the way, think about that for a minute. If we're too stupid or ignorant, to be able to defend ourselves, how could we have been competent enough to have formed the criminal intent to commit the crime? Damn, so simple. But now we have a major constitutional question. And it comes at a great time. As I said on recent videos, I think the U.S. Supreme Court now has our backs. And potentially, this is one of the reasons why. You have to read a lot between the lines. Fortunately, after 5 decades of intense, passionate, and independent study of the Constitution, history, and laws of the United States, I can do it. I think they have our backs. And when we get our questions there, how can they possibly not answer if we don't know where the hell we are? How much worse can it possibly get than that? Of course, the problem is if the other side tells us where they really are, in my case, the territory of California, the whole ballgame is over. My God, that's Pandora's box. If they're a territory, how the hell did they get that way? And like any good legal analyst who goes into court, you don't ask questions you can't answer, but they sure as hell don't want to see the answers. Yet I have every right to get my theory of the case to a jury, which is why in 5 decades I have yet to see one, even in my South Carolina felony case. And I knew from day one when I got arrested in a local library here out of the blue, and I was laughing at them when they were calling back there checking on the damn arrest warrant. I mean, it would have been hilarious if not for the fact that I served 7 months as a political prisoner, having done nothing wrong. And yet, not only will they be paying for it, but with the information I now have, it underscores what I was saying even then. That's the crown jewel of all the unopposed issues I advocate. Where the hell are we? There are no states. And I've got an 83-page legal brief on that subject alone. And you send me an email for information. youwinincourt@gmail.com. And I'll send you back, among other things, the first 5 pages of that brief. 4 solid pages of stellar legal authorities that have never attempted to be opposed. No states. Ball game over. That's what we need to start doing more and more, and I want to help you as much as possible to do it. And you get a lot extra, by the way, with my document packets. And you get complimentary phone consultations, a complimentary appearance at a contested hearing, complimentary updates of documents for 1 year from the time you get them. And I'm going to have some updates on these documents even now with what I've just discovered. I want to put it in most everything I have and make it so clear they can't possibly miss it. I mean, this alone may beat the corruption in the trial courts, and that's saying something. But we've got them now where they can't be sure that, number one, we can't get to the Supreme Court, and I'll get us there on the express train. And number two, if we get there, they can't at all be sure what the hell is going to happen. Given the fact they've never opposed any of my documents, that's basically a routine default judgment. They have the sworn duty to do that, especially when jurisdiction is challenged. And even when it's not, in theory, the government must prove jurisdiction before it does anything. That's the Constitution mandating it, the U.S. Supreme Court saying it, as you will learn with my document packets. It's simple. It really is. Yet it never happens. The reason for that being that it never can happen if we're in a territory, as I've been claiming now for quite a while. And there's no way, because they can't explain how we got to go from a state to a territory. I'd love to hear it. They never attempt it. I mean, not only can they not do it, if it goes on the record, it's going to convict all the actors of treason to the Constitution. And that's the Supreme Court not only saying it. In the case of Cohen's v. Virginia, you'll get excerpts from that decision when you request information from my document packets, youwinincourt@gmail.com. But they have recently cited Cohen's 2 times in the latest term of the court. And you'll get a document also coming your way with a request for information explaining the significance of it, because the court can't cite that decision. People say, oh, that's old law. They don't use that anymore. Ain't. The Supreme Court just did it twice in the last term, trying to explain the fact that there's no way that, they should be able to deny Texas filing documents in a case. So that said, remember to like the videos, tell your friends, and get the word out here. The faster we go in there and work together as one unit, Americans, Asians, Africans, whatever, that's what we have to do. And hit on the broadside with all these issues right in the trial court and set the record. And when you do that, you get an unopposed record. We can then turn around and use against them in an offensive action for petition for redress of grievance. Almost certainly we will never see a jury, let alone have to even file any documents in their corrupt courts. That's the beauty of it. So that said, send me an email, youwinincourt@gmail.com. I'll get you more information out and we can go from there. Thank you.